Good morning, Mr. McCann.
Good morning, sir.
So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
Complainant and defendant are in a former dating relationship. On 6/29, officers were dispatched to a disturbance at a business in Harris County, Texas. Complainant entered the business, and when she exited and walked back to her truck, she observed the defendant there. Complainant believed defendant had followed her. Complainant said that defendant was intoxicated and started to insult her. Complainant stated defendant struck her on the left side of her face with a closed fist as she sat down inside of her truck, causing pain. Complainant stated she went after defendant as he entered his truck and grabbed his shirt. Complainant stated she was momentarily dragged as she held onto the defendant's vehicle.
So it was a hit to the face, you said?
Yes, Judge. We have not been able to arrest her yet. I will let you know that I was reading through the offense report. I don't know if this was mentioned to intake, but in the offense report, it does look like she was 4 months pregnant at the time and the defendant was aware, so this baby refiled.
Whoa, 4 months pregnant during the alleged assault. That's a legal game changer. In Texas, assaulting a pregnant person can raise the charge from a misdemeanor to a felony. Even if the injury was minor, the law takes unborn child protection very seriously. What do you think? Should pregnancy always escalate charges like this?
This is a felony, I'm not sure yet, but throw that right now.
Mr. Tejada, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. If I find that you're using, I will revoke your bond, put you in jail. I'm going to do everything in my power to protect my public at all costs. Do you understand?
Yes, sir.
You are not to have any contact with the complaining witness in this case, not to be in possession of weapons, and I'm now entering what's called a magistrate order for emergency protection. This is a court order that identifies Ms. Lopez Leiva as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Sir.
If you violate this court order, the state can and will probably file a violation of protective order, and that is the capital murder of misdemeanors. It is one of the worst cases you can pick up, a violation of protective order. Do you understand?
Sir.
You pick up one of those, violate conditions, I can have a hearing to hold you at no bond, zero bond, and I'll do it in a heartbeat to protect my county. Any prior assaults against this person or?
No, Judge, this looks like it was the first one.
Okay. Now, you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Parr. If he tells me he can't get a hold of you because you've gone AWOL, I will issue a warrant for your arrest. You pick up a new case, I will issue a warrant for arrest. You get no more PR bonds. Do you understand?
Yes, sir.
You will be randomly called upon to go take drug and alcohol tests. If you fail to go, then likewise a warrant for your arrest will be issued. I'll have you go sign a reset with Victoria. You'll sign the order for protection here. You'll get with, police you for your bond conditions, and after that, you're free to go.
Just,
Oh, is there no bond set?
well, no,
Oh, there is.
Bond said, Judge, with regards to the bond condition, I was wondering if we could, amend those or have them reflect the no threat and harassing communication, instead of no contact.
They haven't been able to reach her.
They haven't, but the DA hasn't, but that she has spoke with her back. And she had spoken to the back and told her that she didn't want to proceed with the case. She would,
I don't know. I mean, if she's 4 months pregnant, you
no, she's
know,
already had the child. They already have a child now. That's the only reason why I say it now,
Yeah,
because
this did happen back in June.
they do have a,
If,
child.
let's do this. I want to know, I mean, if that VAC was done, that VAC was done in 2024. I don't know anything recent. So until I know what she wants now, then, you know, and if you could, you know, facilitate, perhaps give a phone number, maybe that's something that can happen now. I don't know, but I like to follow the wishes of the complaining witness, and I don't know what her wishes are. If she doesn't want contact with you, then I'm gonna order it. If she does, then we can revisit it at that time. But understand, for this instant, no means no. It doesn't mean maybe. It doesn't mean I gotta go get my kid. It doesn't mean someone has to go take the SAT. No means no. Do you understand?
Sir.
Okay. All right.
Thank you.
Thanks, guys.
Judge.
This way.
Good morning, Mr. DePaz.
Good morning.
So you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
Oh, thank you. Okay.
On March 10th, 2025, at approximately 12:18 p.m., a school resource officer responded to a security officer needing assistance in LaPorte High School. Upon arrival, the defendant was placed in the security resources office after a physical altercation. The defendant stated he was upset with the complainant because the complainant had mistreated his sister in the past. The defendant confronted the complainant and struck the complainant with a closed fist on his face. The defendant was observed on school CCTV walking up to the complainant and punching him with a closed fist, and shortly after, the complainant fell to the ground. The complainant did not show signs of confrontation towards the defendant. The complainant was observed with multiple lacerations on his lower lip and a missing tooth from being struck in the face. The complainant was also observed with a swollen jaw and bleeding from his mouth, and the complainant felt pain. I have spoken to the family of the complainant. He's had to have his jaw wired shut. His jaw was broken on both sides of his face.
Serious bodily injury?
I don't believe that would rise the level of serious bodily injury because it's not permanent disfigurement, because he will heal eventually, but it will take 6 to 9 weeks.
Mr. Topaz, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're smoking weed, if I find that you're using alcohol, I will put you in jail. You will get your degree with me. Do you understand?
Yes,
You
sir.
are now not to go back to LaPorte High School. I'm ordering you not to go back. I don't want this person to live in fear, so you're not to go back there. Do you understand?
Yes, sir.
If I find that you become a danger to my community, I only have one place for you.
Yes, sir.
You're not to be in possession of weapons as well. You were what, 17?
Yes, sir.
Okay, I will provide you a lawyer today. I'm sending you for a drug test. I want to know what, if anything, is going to be in your system. You have to take a test and you're to come back, and then I'll have you speak to a lawyer.
Yes, sir.
If you don't go take the test, if you don't come back, I will issue a warrant for your arrest.
Yes, sir.
I need your problem. You got out of jail because we gave you a free bond. You're not going to get another one if you're a danger to my community.
Yes,
You
sir.
understand?
Not causing.
Okay,
And Judge, did you say no contact with the complaining witness?
Correct.
Okay.
but don't worry, don't file anything because I'm going to have him supervised. All right, so just reach out to the MAC form, please, and then I'm going to send him for a test right now.
Okay. Well,
Rand. How are you? Right, how are you? Judge looks very festive today.
So this is an FSGI, am I right?
Yes, sir. Hola, yo te voy a interpretar, ¿ok?
Good morning, Ms. Reyes.
Díaz, señora Reyes.
Good morning.
Ms. Reyes, you're charged with failure to stop and give information. Essentially, leaving the scene of an accident without exchanging information.
Escena de un accidente sin intercambiar la información que necesitabas hacer.
We're facing up to 180 days in jail
180 días en la cárcel por
and or a $2,000
una
fine.
multa que no sobrepase $2,000.
We are going to do probable cause.
Los soldados
You have the right to remain silent. Anything you say can or will be used against you.
está contra usted.
I insist she stays silent.
Y tu abogado insiste que se quede callada.
Just please go slow.
yes, Your Honor. On March
El
10th,
10 de marzo
2025,
del 2025,
officers were
los
dispatched to
oficiales
Safer
fueron
Street
a
and
una calle Safer
Seth Street in reference to an
Seth Street.
FSGI.
bajo una referencia de faltar y dar información.
The officers were
Los
advised that a white Charger
oficiales
left the scene
dijeron que
following
un
an
White Charger
accident
se fue de la escena después de un accidente
and was last seen
y
going
lo
southbound
vieron
on Shaver
y iba
Street.
en camino al sur en la calle Shaver.
The complainant stated
El
that she
quejante
was
dijo
traveling when a
que ella
white
estaba
Dodge
manejando
made a
cuando un
unsafe lane
Dodge
change
Cambió de carril, pero
Eh.
sin,
and collided with her.
y chocó contra ella.
The complainant
El
showed
quejante
officer a
dijo,
picture of the
Él
suspect
tomó
vehicle,
una foto del vehículo y le enseñó
Which-
al oficial
showed the license
y
plate
tenía la
and
placa.
damage to the vehicle
y
on
el
the back
daño al
left
vehículo.
portion. The complainant
El
estimated that the
quejante
damage was
dijo que
around
él
$1,000.
está estimando que costó como $1,000 en reparación.
Officers ran the
Y los
vehicle and
oficiales
found the registered
Vieron la
owner to
placa
be
y
Juan Maneno.
encontraron que el dueño era Juan Veneno.
The officer located the vehicle at the apartment complex
Encontraron
that the
el
vehicle was
vehículo
registered
en
to.
los apartamentos a donde estaba registrado.
The officer met with
Y
Juan
el
and his
oficial
wife, who is
habló
the
con Juan y
defendant.
la esposa, que es el acusado.
One, advised the officers that the
Y Juan
defendant
le
had been
dijo
driving the
que el
vehicle all
acusado
day,
estaba
that
manejando
the
todo el día el
and
vehículo
that the only damage to the
que
vehicle should
cualquier
have been on the
daño
front bumper from a
que
previous
tenía el
incident and
vehículo era
nothing
en la
else.
parte de frente de un accidente previo.
The defendant
Y
advised
el
officers that
acusado
she was
le
driving the
dijo
vehicle and
que
had
ella estaba
recently gotten
manejando
back from a Walmart,
el vehículo y había regresado
which
de
is around
Walmart
700
como
feet from where the incident
700
occurred.
pies de a donde ocurrió el
She denied hitting
incidente
anybody.
y ella negó pegarle a cualquier persona. Negó que
Your Honor, so based on the
y
information,
basándome en la
the
información dice
car was registered to his wife.
So, how do we know who's
And
driving
he
it?
complained,
y
the
cómo sabe quién está
Juan stated that he
manejando.
was the one driving and she admitted to being in that location at the time.
She denied hitting, right? Do we have any kind of evidence that puts her at the scene that she's the one that causes the accident?
Que ella estaba ahí y causó el accidente. Go ahead.
That she
Sí.
was the one, within 700 feet of the accident and that she had
Estaba
access to the vehicle.
And just like that case dismissed. But let's unpack this. The husband said she was driving the car all day, but no video, no eyewitness ID at the scene, no slam dunk proof. It's a reminder, in court, maybes don't cut it. Would this outcome frustrate you if your car was hit? Tell us below.
Tenía acceso al vehículo y estaba 700
And this
pies
vehicle was the one that was in the
del lugar.
accident.
Y ese fue el vehículo que estaba en el accidente.
Did you say that the husband said that she was driving it?
She was driving
El
it all day.
esposo dijo que estaba manejando.
statement.
Dice que sí.
Do you want to add anything? Did you want to say anything?
No, well,
Yeah,
two
yeah,
things,
yeah.
Judge. Number one, there was no evidence that
No hay
she was,
evidencia.
as you mentioned, there was no evidence that she was
Que ella
driving the
estaba
vehicle. And just because she had the vehicle all day does
Solo
not mean she
dice
was
porque
driving
tenía el
it.
vehículo ese día.
For example,
No
when I'm sure my
significa
daughter's
que estaba
home,
manejando.
I'm sure,
Porque cuando-
and she's using one of our vehicles, I'm sure that
Mi hija
her lunkhead
estaba usando-
boyfriend is probably driving it the majority of the
vehículo
time.
puede ser que
Additionally,
no,
this
el novio de
vehicle
mi hija
is
estaba
insured.
manejando. Ahora el vehículo
There's
está-
never been
tiene
any
su- está
report
asegurado.
of anyone, but people had consent to driving it. That defense is not going to be erased, so this is an
Yes, sir.
insured incident.
Eso es un incidente
You got A, you got C, but you don't have B. I mean, I just don't think that,
A ver,
officer could have gone to Walmart, pull video, see her coming out, other
pueden ir a Walmart a ver si
cameras anywhere else. I don't know, but I just,
no hay
I
prueba
don't think there's enough.
Okay, sure.
All right, I'm gonna find no probable cause in your case,
para
man.
encontrar que hay motivos fundados para mantener, pero
Please be careful when you're driving.
ten cuidado con
If you're going to drive, do not drive unless you have a valid license
no manejar
and liability insurance in your name.
y seguro.
Do you understand?
¿Entendido?
Okay, all right.
And she does,
Yes.
for the court's edification.
Thanks, Randy.
Always great seeing you, and I apologize on the record for calling in my future son-in-law as a lunkhead, in case that goes anywhere. I forgot it's being videoed. All right, take care.
The cause?
I keep forgetting.
Are you Ms. Jacobs?
Yes, sir.
Ma'am, you're charged with failure to comply, I guess striking an unattended vehicle. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On February 27, 2025, an officer responded to an FSGI call in the HEB parking lot in Houston, Harris County, Texas. The complainant reported that while shopping, her vehicle was backed into by an unknown individual who did not stop. When she returned to her vehicle, a note was left with a license plate number, a witness's phone number, and a statement about the incident. The witness confirmed seeing a vehicle back into the complainant's vehicle and drive off. The witness gave a description of the defendant and her vehicle. On March 4th, 2025, an officer met with the loss prevention manager at HEB and was shown surveillance video from the parking lot, which showed the defendant driving over a curb and parking her vehicle. The defendant did shopping in the store and got back in her vehicle. The defendant began to reverse into the complainant's vehicle. The defendant paused briefly before driving off and exiting the parking lot. Surveillance video clearly showed the defendant as well as the defendant's vehicle's license plate. The officer confirmed the license plate was registered to the vehicle and the registered owner was the defendant. The officer compared the driver's license photo with the surveillance images and positively identified the defendant. The officer called the defendant and the defendant acknowledged he rubbed another car with her bumper. The complainant provided photographs of the damage to her car along with an estimate that the total cost of repair would be $3,009.23.
Okay. Ms. Jacobs, I'm going to find that there's sufficient probable cause to go forward with the case. Can you run her license, please? See if she has a valid license.
Yes, Judge.
I'm ordering you not to drive any vehicle unless you have a valid Texas driver license and liability insurance in your name. That's the only condition I'm putting on you at this time. Do not pick up any new cases. If you do, I will revoke your bond, put you in jail. No more PR bonds. Do you understand, ma'am?
Driver's license is valid.
Okay, so we're just going to craft bond conditions for you not to drive without without insurance as well. We'll have you sign it, and after that, you'll be free to go. You have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him, and he'll tell you if and when you have to come back to court. If he tells me he can't get hold of you because you've gone AWOL, I will issue a warrant for your arrest. All right? We'll have you sign a receipt with Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. All right? Thank you, guys.
This way.
Good morning, Mr. Macias.
Buenos días, señor.
Sir, you were charged with assault, bodily injury. You're facing up to a year in jail and/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Quiet.
You have the right to have an attorney present.
El derecho de tener un abogado presente.
If you cannot afford one will be appointed to you.
Van a asignar un abogado oficio.
On March 10th,
El 10 de marzo del
2025,
2025,
at approximately
aproximadamente
5:03 p.m.,
5:03 de la
an
tarde,
officer
un
was
oficial
dispatched to
lo
a
llamaron
disturbance
a una
unknown weapon call
con una
at a
llamada de
residence
que tenga una
in
arma
Harris County,
aquí
Texas.
en una residencia en el condado de Harris.
The officer made
El
contact
oficial hizo
with the
contacto con
defendant
el acusado, usted,
and complainant
y el quejante
on the sidewalk of
ahí
the
en la
residence.
acera de la residencia.
The officer
El oficial
observed the
observó
call was related
Que la llamada
to
era
a previous
relacionado a otra llamada
on
previa
March 6th,
del 6 de marzo
2025.
del 2025 que estaba
The defendant stated his right
acusado
hand
dijo
was
que la mano
injured
derecha le hicieron
approximately
daño
3 days ago
hace como 3 días
because he fought with the
porque había
complainant
peleado con el
who
quejante
beat up the defendant
que
and that he was
había
sitting
dado
outside
golpes
playing
y estaba
guitar
afuera
on the day of the
tocando
incident.
guitarra el día que ocurrió el
The
incidente.
complainant became upset
quejante
because he
se
did not
enojó
like the noise and that
porque
the
no tenía,
complainant
no le gustó el ruido
complains about music all the time.
y él siempre está
And-
quejándose sobre la música siempre.
And that the complainant caught him
Y
at a bad
quejante
time
lo agarró un tiempo que estaba
because he
tomando
was
unos
drinking
rollos,
alcohol
que estaba tomando
and was
alcohol
angry.
y estaba enojado.
The defendant stated he was tired
El
of the
acusado
complainant
dijo
constantly
que
bothering
estaba
him,
cansado de que él siempre se está molestando
that the complainant deserved to get beat up,
y le merecía que le
and if
dieran una
officers
paliza
released
y
him,
los oficiales
he would
lo
show
dejaran
them what he
ir.
could do
Le
by
iba a
assaulting
enseñar
the complainant
qué ibas a
again.
hacer por agredirle otra vez.
The defendant stated he did
El
nothing wrong.
acusado dijo que no hizo nada mal.
The complainant stated
El
that on
quejante
March 6,
dijo que el 6 de
2025,
marzo del
he was
2025
assaulted by
lo
multiple
agredió
males.
varios hombres.
He was taking out
Él
the
estaba
laundry when
sacando
the
su ropa
suspect started
sucia
calling him
Cuando los sospechosos
racial
empezó a llamar
slurs,
a un montón de
assaulted
palabras
him,
raciales y le
and dropped him
agredió
to the ground.
y le tiró al piso.
The complainant stated the suspect
El
punched him
quejante
on the
dijo
right
que
side of
el
his face
sospechoso le pegó
with
en
a
la cara
closed
derecha
fist, causing
de la
pain.
cara con un puño
He
causando dolor
sustained
y
an
le
injury
dio
to his right knee
un-
and right
una
hand
lesión en la rodilla derecha y la mano derecha.
and left side of his torso was
Y en el
hurt
lado
as he
izquierdo del
believed he was
torso,
kicked.
pues parece que él cree que le habían dado una patada.
On March 10th,
El 10 de
2025,
marzo
the complainant
del
stated
2025,
one of the suspects
antes dijo
who attacked
que uno de
him
los sospechosos que le habían
on March 6,
atacado el 6 de
2025,
marzo de 2025
was at the location.
estaba en ese lugar
The complainant pointed at the
y el
defendant
antes le apuntó
and stated he
al
had to go to the hospital
acusado
due
y
to
le dijo que
injuries.
tenía que haber ido
Did he
al hospital.
identify him?
The defendant was
Lo
identified with
Lo
his Mexican
identificó
voter ID card.
con
Yes, the
tarjeta de
complainant
votar
pointed at the
mexicana.
defendant, stating he was the
Él
one
lo
who attacked him
apuntó
on
al
March.
acusado y dijo que él fue quien la atacó.
Mr. Macias, I'm going to find that there's sufficient probable cause to go forward with your
Yeah.
case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness,
Que no tengas ningún
not to be in possession of weapons, not to go within 200 feet of where he lives or where he works.
Vive o trabaja.
I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you because they sweep it daily, they will put an immigration detainer on you and you will be stuck in custody until this case is over with. And then you get shipped off to immigration, where you'll sit for another 6 to 9 months. I do not want that to
Esos
happen.
9 meses.
And don't
Es que eso.
become a danger to my community. I don't care what is going on in your life. I don't care who bothers you. If I find that you pick up another case, you become a danger.
Otro caso.
It's not going to go well for you.
Peligro a esta comunidad no te va a ir bien.
You understand?
¿Entendido?
This judge isn't just warning, he's practically giving a life lesson. If immigration gets involved, this defendant could face months in custody after this case. It's a powerful reminder. One charge can trigger a chain reaction, especially if you're not a citizen. Do you think courts should consider immigration consequences in bond rulings?
Sí. Yes.
Do you have a lawyer today?
¿Tienes un abogado hoy?
No lo tengo.
No, sir. No te
You have
no
the
hay
ability to
abogado.
hire a lawyer.
¿Tienes la capacidad de contratar un abogado?
De momento estoy fracturado, no.
At this moment, I have a fracture.
You have the ability to hire a lawyer.
¿Tienes el dinero para contratar un abogado?
De momento no.
At this moment, no.
I'll have you fill out an application. I'll see whether you qualify.
I don't know.
I need to know everything about you. I need to know how much money you have in the bank,
Todo.
what you have money coming in, what kind of property you have, and then I'll take a look. We will create bond conditions for you.
Pues va.
Did you say that alcohol was a factor in this?
Yes, Judge. The defendant
Preguntó
stated
si había
he
alcohol
was
en este
angry
caso.
because he
Dice
was
que sí,
drinking that
porque
day.
estabas enojado ese día, porque estabas
I'm
tomando
also
ese día.
ordering not to consume
También
alcohol,
te voy a
legal
ordenar
drugs.
que no tomes alcohol.
Test you. Mr. Macias, if I find that you're consuming alcohol, likewise, I will put you in jail.
Encuentro que estás tomando
Do you
alcohol
understand?
en la cárcel, ¿entendió?
Sí.
Yes.
I will, Deputy Miranda's going to give an application. I'll have you sign a receipt with Victoria. You'll get with police if you bond conditions, and then we'll have you take a seat with
Y
your
vamos a ver
boss.
si te vamos a dar un abogado de cuánto quieres de fianza. Pase allá.
Don't worry about filing conditions because
I have a plea, Judge.
you ready?
Yes, Judge. Felipe Alvarado.
Mr. Alvarado, come up. Hi there. Hey. Hey, the lady from yesterday, is she up here?
Sí, señor, no, señor.
Mr. Alvarado, you were charged with driving while intoxicated. You were facing up to 6 months in jail and/or a $2,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you have done. You need to understand that this charge will go on your record after today, and it will be there for the rest of your life. From now on, you will be facing a minimum of 30 days in jail for any new cases that you pick up. So no more slaps on the wrist, as it were. You get pulled over from now on, and you have the slightest smell of alcohol in your breath, an officer sees this DWI. It's probably not going to go well for you. Do you understand?
Yes, yes, sir.
Giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take it off. Is this what you want to do?
Lo que tienes que hacer es lo que quieres hacer tú. Dice que soy culpable. Soy culpable. I am guilty.
I'm going to find you guilty. I will follow the agreement. The other thing is that there is a $3,000 surcharge that tacks onto your license and onto you when you pick up a case like this. I will waive it today. But if you continue to endanger our community, the next time a second offense, it's a $6,000 surcharge. And if you don't pay it, every $100 you owe you sit 1 day in jail. So get a clue. From now on, if you want to have 32 beers, 52 shots, take an Uber. It's not hard. I am going to suspend your license for 90 days. Do not drive until you get a license. And good luck to you, sir.
Buena suerte.
No, he'll pay for this. Yeah.
First man, Alred Brown, it's an arraignment and a motion to sub.
All right, come on up. You ready? Bring your client.
Was it filed today, Councilman?
Page 6.
Motion to sub, I think we filed it here yesterday. But it had been filed a while ago, wasn't it? I think just recently.
I think it makes a little time.
It's already a round.
Yeah. Those were taxes.
I think it's already, Aircon's already.
Okay, just making sure my notes just said
Good
motion.
morning.
You're Alfred Brown.
I am.
If you're facing an assault causing bodily injury, you're facing up to a year in jail.
I don't believe so, Your Honor. I believe this is an
me.
interference with
I'm
the
sorry.
public
Right,
service.
I'm looking.
Yeah, and that's not
Yes,
me.
you're right. Interference with the duties of a public servant. 6 months in jail and a $2,000 fine.
Quiet.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 11th, 2025, at approximately 1:21 p.m., the officer observed a vehicle speeding at 48 miles per hour in a 35 miles per hour zone, and a temporary tag that came back as expired as of March 3rd, 2025. A traffic stop was initiated. The defendant stopped in the middle of the road, and the officer signaled for the defendant to pull over to the nearest parking lot. The defendant opened the driver's side door and attempted to step out. She became hostile and then was yelling and cursing. The defendant was giving commands to walk in front of the officer's patrol vehicle. Since the defendant was not complying with commands to get back inside the vehicle, the defendant then walked partially to the back of their car, and the officer detained the defendant and began actively resisting. The defendant was given multiple commands to place their hands behind their back, and the defendant continued to pull away and tense on the officer's attempt to walk them back to the car. The defendant then locked onto the door to prevent the officer from placing handcuffs. The defendant was taken to the ground where they continued to resist. The defendant was tased after giving repetitive commands and not complying. The defendant was then successfully placed into handcuffs, and it was later learned that the defendant had an unloaded firearm in their vehicle and was identified by their Texas driver's license.
Okay, I'm going to find that there's sufficient probable cause to go forward with the case. Can you run the license, please? Make sure it's eligible.
There is no driver's license on file, Your Honor.
Yeah, and I have it eligible. My driver's license is valid.
Unless you have a valid Texas driver license and liability insurance in your name, you're not allowed to drive. It's a condition of your bond. That's the only condition I'm going to put on you. Just when you get into a pissing match with someone with power of arrest, who's going to win? Don't say anything as a rhetorical question, but really, people have been shot for far less. You got to be careful in this life. You only get one. You know what I mean? Really.
Yes, sir.
All right. I'm not, like I said, the only condition is just drive with a license and insurance. You've got lawyers, so they'll take care of you because you have a lawyer. I will waive your appearance. You don't have to waste your time coming to court, but just stay in touch with them. They'll tell you if and when you have to come back to court.
Yes,
If
sir.
they tell me if they tell me they can't get a hold of you, if you take off, you pick up a new case, I am going to revoke your bond, put you in jail. No more PR bonds. Just be nice. It's not hard. All right?
Yes, sir.
I'll have you sign a receipt with Victoria. We'll have you take a seat while I get your bond conditions. We'll have you sign it, and then you're free to go.